Welcome back to the Art of Outsmarting. Today you're going to hear Keith delve into the world of evidence analysis. This deals with things such as taking the depositions, building the foundation of your case, making sure your client is prepared. If it comes to cross-examinations, it's getting those sound bites. And again, doing all of this is really step one at having a successful outcome of the case, whether it's at mediation or whether it's at trial. I think you're going to find this information really useful.
Personal injury cases hinge on the details. ABC Legal, America's most trusted process server, simplifies every aspect of service, so you can focus on winning your clients' cases. ABC Legal-empowered process servers deliver documents nationwide and make 12 million attempts annually, with real-time GPS-tracked updates and proof available online. ABC Legal's simple and transparent services make life easy for your team and help you keep costs under control. Your clients deserve consistent, reliable, and accountable service of process. Sign up for a free account today.
Okay, we're ready for the second episode, and this one also came from our survey when people asked for it. So you ask and we're going to deliver. And this one really was about evidence issues, and I got thinking about it and how could we make it fit into this setting where everyone could hopefully get something out of it, because just speaking about getting something specific into evidence is so dependent on what state it is and what law it is. But I realize there's a piece of this that I think may really be useful talking about the evidence side. So what we're really going to be focused on is what I talk about is being a bodyguard while building a war chest. And what I mean by that is the whole time we're doing, I don't like to say discovery because people think boring and they end up shortchanging it. I think of it as the workup phase, particularly trial prep. Because when you're taking a deposition, you're preparing for trial. When your client or your witnesses are being deposed, you are preparing for trial. And preparing for trial is a hell of a lot more interesting, and it's easier to focus, and you feel less sorry for yourself if you think about it as trial prep, not boring discovery or deposition taking. But whatever label we put on it, it's essential, because what happens in the depositions that you take and the depositions that they take leads to what the evidence is going to one day be at trial. And whether it comes out right or wrong makes the difference between the value of your case for settlement and the likelihood of your chances of winning it when you get to trial. So I want to cover all of that, but all of it with an eye towards what are we going to do at trial with this evidence? And we need to get it in, and we need it to be the most powerful, and we need to minimize as best we can the evidence that's hurtful for us. But it goes all the way back to this workup phase or trial prep phase with a focus particularly on the depositions. So, and I know you are still living in the world of depositions.
Oh, yes, I am. Day in, day out.
So this is one I'm going to lean on you for some input, because I still do some depositions, but they're almost exclusively now. Someone asked me to come in and do a videotape cross-examination of the other side's expert. I don't do the discovery depositions anymore. I did a whole bunch of my career. I paid my dues, but I don't do them anymore. So you're probably a little more fresh, up to date, some of the more latest things. But I do have some thoughts on what's really important about it. When I said at the beginning, it's important to do what I call being a bodyguard. Mm-hmm. We all know I want to go get stuff to help my case. But we can't ever lose sight of how important our role is to protect our witnesses, particularly our client, from someone on the other side who's trying to get stuff to help their case. And if we shortchange the bodyguard part, we're really doing a disservice. And being a bodyguard is a cool part of what we do. It's important. We get to defend people, protect people. Even though we're not defense lawyers, there's still a defender role. And being a defender, being a bodyguard is something to be proud of, something to really perfect. And we think about being the tip of the spear, and we want to be up front building our case, but we also have to be guarding the back end. So that's really what I want to talk about. And as we go through this, let's start with being a bodyguard for your client. We all know the worst thing our client can do, and they seem to do it over and over, is they say, I didn't have this problem in the past, and they did.
Surprise.
Surprise. And I don't know why, because it's so prevalent. And I see it at the other end and how big of a hurdle it creates. I've spent time trying to figure out how to stop it, and in order to stop it, I've tried to figure out why. And I don't know why. I think it's different. I think some people may just be hiding it. But I think most of our clients are truthful people, and I think they either genuinely forget, they misunderstand what's really being asked. They think it's all about this injury, not a different one. And I think some of them are truthful people, but they've been picked at and prodded at. And they know the other side's trying to suggest they're making it up or they're exaggerating. And they're offended by it. And so they get asked about something in the past, and I think without thinking through it, some of them just go, I'm not going to give them that. They're going to make it into something that's not true. It's got nothing to do with this case, so I'm going to say no. And I don't think it's a lie so much as I think they're being defensive. But whatever the reason, it's a hell of a problem. And I'd like to head it off. And I know simply telling them to tell the truth isn't working, because I know every single one of our lawyers tells them, and it still goes south. They get nervous, they screw up, whatever reason. So I've designed some things that I think really help with that part. And while this is about evidence analysis ultimately for trial, we got to back up into the trial prep phase of depositions, because that is the pool for so much of our evidence comes
It's
from.
the foundation, right?
It comes at it. And if we do it right, then our evidence at trial gets better. I want to start with being a really efficient bodyguard for your client with a mind towards priors and things like that, and some others. Before we tackle priors, I want to talk about some other things as a bodyguard you can do to protect your client in their deposition. Here's one of them. Don't let them say, I can't. I want people to think of can't as a curse word. Would you ever have your client in a deposition drop the F-bomb? No. Would you at trial say F? No. Think of it the same way. Can't is like dropping an F-bomb. Because if your client's in a wheelchair and they're paralyzed, they can't walk. Don't worry about it. Say they can't walk. But the vast majority of cases aren't can'ts, they're don'ts. You mean they don't pick up the kids anymore and throw them around. They don't golf or whatever it is anymore. They don't jog anymore. You will say they can't jog. They can't lift their kid over their head anymore. Yeah. They can't jog anymore. And they really mean they don't. It's loose talk. The problem is, do it once or twice, nobody noticed. Do it over and over, your client looks like they're exaggerating. Because everybody knows when they learn about the injury, you could do it. You don't do it because it's not worth it to you. The little thing of beating that into your client. And if your client says can't, take a break. Take them. Say if they do it once, don't worry about it. They do it twice, get nervous. Do it 3 times, take a break. Get them outside and say quit. Now, if you're in a venue where you can't talk to your client once your deposition starts, then play by the rules. Do not do something ethically wrong. Most places in a discovery deposition, you can talk to your client. Or if not, interrupt them.
Yeah.
Say you just said can't. Did you mean can't or don't? Because you will have lectured them on it. It'll remind them. And they're going to say, quit coaching your person. Say, I'm sorry, you're right. And you don't have to hopefully keep doing it. If they keep doing it and you can't fix it at the end, fix it with some questions of your own. Make the list that you can't. Did you mean you can't or you mean you don't? Go through them with them. But it starts in prep. Sit them down and explain to them, here's what you mean. I don't because it's not worth it. And if I do it, there's a price to pay. My pain goes up. And I've learned it's not worth it to me. I don't do it. Doesn't mean you couldn't. And if it's an emergency, you can't run. If your child was out in the road, you could run over and grab them. You may be on a heating pad for the next day, but you could. Explain it. Explain how it looks when you say it wrong over and over. And tell them, get can't out of your vocabulary. I don't is the substitute. I don't do that anymore. I don't do that as often. I don't do it the same way I used to do it. All of them are variations of don't. It's important they understand can't. And if you don't have that conversation, you're a lousy bodyguard, because they're going to say, I can't. And the defense is going to get up and say, they said they can't. And what if they get surveillance and they're doing it? And they happen to catch them a day they did, because they can. But even if they don't, the constant can't sounds like a whiner that's overstating their case. So that's an important part of it. Another one is, when they know something's true, say, I know. Remind them it's better to say, I think. Like, have you had any crashes in the past? I can think of one. I can't think of any other. It's so much better than, no, I know I didn't. Think of as the lawyer, the difference when you went and read it and said, I don't think so. I don't remember, as opposed to, no, I've had none. Think of how that plays different.
Huge difference.
Huge. This is part of the prep of a client, and it's part of being a bodyguard, because we know what's coming, we know the mistakes, and we know a certain just verbiage can provide great global protection. You don't say, I can't, you say, I don't. You say, I don't think, as opposed to I don't know, or I don't recall. These little things make a difference. Here's another one, before we get into the big one, priors. If there's a problem, fix the mistakes at the depot. If you can fix it at the time, fix it. If you can take a break and fix it, if it's allowed. If not, at the end, before you come back in and say, you said X, Y, and Z, cover them. Did you mean? Did you lead them? You're not going to be playing it at trial. What do you give a damn you let them? Then they say objection, lead, okay, did you mean? Yes, they'll answer right. Fix it on the spot. Because when you fix it live, it looks like a brand new story. If it was fixed then, they get up and impeach them. You say, did you correct that back through 2 years ago when you're yes, I did. It just doesn't have the same sting. So fix them at the time. Now, one more, and then we're going to get into the big priors. It's important to prepare your client for the damage questions that are coming. How does it impact you? Clients do not want to think about all the little ways it impacts them. It's depressing. If they sat around and thought about it, they would be in worse shape mental health-wise. I applaud they don't want to think about it. But if you have them say, tell me how it affects you, and they say, well, I can't golf anymore, and I can't go on my snow trip once a year. When I clean the house on Fridays, I got to take breaks. All of that's true. A, no one gives a shit about any of it. They don't care if you can't golf. B, it sounds like, okay, once a year you don't get to go on your ski trip, and heaven forbid one Saturday a month you don't get to golf, and on Friday you got to clean different. Who's going to give you money for that? Nobody. Is that all this injury amounts to? No. Why is it they go to the big things that jump out? Why are they going to the big things that jumped out? Because you didn't do your job of being a bodyguard and prepare them for all the little things. The reality of the injury and the value of what was taken comes from the little things. The little things that happen all the time. When you live with pain, it's having an impact most of the waking hours and including the sleeping hours. Your client doesn't realize it because they're not sitting around thinking if they would be whiners. But your job is to make them do the depressing thing of thinking about it in advance of a weird thing called deposition. So I give them an assignment, or I did, and I would recommend, give them a take-home assignment. Give them a little pad to write on. Go get a moleskin from Barnes & Noble, whatever. Give them a pen and tell them to carry it with them. And for 48 hours, I want you to write every petty little thing. And here's the key. I want you to make a list of all the little things that you either don't do or you do differently, or if you do it, there's going to be a price to pay for it. And I explained to them, here's what I'm going to tell the jury one day. I'm going to say this has taken my client's freedom to live life without making all these little mini choices all day, every day. It is taking from them no matter what their choice is. If they choose to go on and do it, there's a price to pay either way. If they do it, their pain goes up. If they choose not to do it, they've given up something they would have done otherwise. So there's a price to pay either way, and they're making choices almost subliminally without thinking about it all day. And I'm going to tell the jury that's what's been taken from them, the freedom of live life without making all these many choices every day to do or not do, knowing there's going to be a price to pay either way. And it's going to be powerful for the jury. And they're going to understand the reality of what this injury is thrust into your life unnaturally. But I can't do it. If they ask you, how does this impact you? And you say, I can't golf. I need these. And you don't know them because you don't want to think about them, and I don't encourage you to ever think about them except right now. Take this for 2 days. Every time you make a mini choice, I want you to be on alert for it, and I want you to write it down. And after you give me that book, we're going to go through it, and I don't want you to ever think about it again until you have to testify at court, because it's not the way to live your life. But I need you to go into the dark place and find it for me now. Then you take the book back. They will be teary-eyed when they tell you they don't know. I know, I got back problems. I don't want to think about all the little choices I make. I do every day. I've done them so long I don't even know I make them. They don't know they make them. You need to know they're making them. You need to know what they are. There are going to be things that sound petty. Take them off the list. There are going to be things on there that are significant that sound petty, but you're going to go, that's like I picked my child up different. That matters like $1 million more than golf. Jurors go, oh, you say golf, they go, I don't give a damn. You got time to golf? I don't. Even the golfers don't give a damn. They don't think it's something you ought to get paid for. So make them make the list of the many choices. Then you cull through it, pick the ones that are powerful. Before you're being a bodyguard. Why is this being a bodyguard? You're still not being the tip of the spear, you're being a bodyguard. Because if you didn't, you know what they're going to say? Golf. You're going to get them ready for this because you thought ahead, you knew what was coming. You're going to go through and say, here's your list. I want you to read this over. I'm going to keep the list. If you don't remember it, I'll ask you at the end of your depo about the ones you skipped. They're going to say, how does it impact you? Your answer ought to be, I make a lot of little choices. Like what? Here are the important ones. Give them. If you skip some, I'll fill them in. Or at the end say, that's not all of them. They're the ones I can think of. Now, think how much more valuable that deposition is for your upcoming mediation or your trial. Because if they limit it, you get up and say it, the good lawyer on the other side is going to say, we asked you how to bother, you didn't list one of these. Look here, not one of them. Now they've listed some. They listed 5 and you do 7 at trial. Who cares? No one's even expecting them to remember them all. The concept got out with some meat on the bones. That's being a bodyguard. Now, let's go into priors that our clients, for whatever reason, struggle with. Remember, I have a system I came up with that I keep asking our lawyers to give me feedback if is it backfiring. And I've yet to hear a single backfire because I hate giving this kind of advice out to people and then there's something that backfires. Because I developed it after I stopped taking the depots, so I don't have firsthand experience. I think it's safe and I know it works. And it's this. There are going to be exceptions with court orders, you have no choice. But if you have a choice, do not let your client sit for a deposition until you've forced the defense to give you every third-party subpoena they've sent. And if they haven't given them to you in writing, saying that's it, because back when I took them, I would have them give them to me, and lo and behold, the one that had the great answer in it, they would say, I don't know how that didn't come through the copying.
Yeah, convenient.
So have them bait stamp them and give them to you. And warn them, if there's something in here that helps you that's not in my production, we're going to have a big problem. Spook them out of it. And if they say, I'm having a hard time getting this one, then fine, we'll reset the depot. Don't let them there unless there's some deadline you have to without him. And then don't not read them or have someone you trust that knows what to look for dig through them. And for God's sake, pay attention to subsequents in PT records. Physical therapy records are the bane of my existence at court. They all want to look like heroes, like they've solved it all so they can get paid for their, rubbing their foot or whatever the hell they did for them. There's almost always something bad in there. They got to be combed through. Priors, comb through every record. Don't say, oh, this is a gynecologist, I don't need to look. The damn gynecologist always has something says neck supple, pain-free. I don't know why they're messing with necks, but they do. And they write it because they aren't messing with necks, but they write it. It's okay if you know. You need to know everything that's in those old records, not just the obvious places to look. The gems they find to hurt you are going to be in the non-obvious places. So have someone go through or personally go through looking for the things that are going to attack your client because you're being a bodyguard. Then, once you have it, do two things. Take excerpts of all the stuff they're going to be excited about. Put it in a binder. Not all the records, just the excerpts. If this doctor has 3 things, put his name, 3 things. The next doctor, they're going to be like 5 of them. They're never more than about worst day 10, usually 5. Have them in a little simple binder. Make a copy for them, for the court reporter, for your client, for the defense lawyer, and for you. Go through it when you prepare your client. Talk about the priors. Give your client an assignment to talk to their family and loved ones and to think about any priors. Make a list from the records and from what they talked about and put, here they are. On one piece of paper, have your client hand write them. Make copies of those too. Go to the deposition. Before it starts, say, Madam Court Reporter, I want to mark as Plaintiff's Exhibit 1. It's a binder of excerpts from medical records with the priors that we're aware of. Hand the defense lawyer one. Have your client sit down with one. Give one to the court reporter. Keep one. Say Exhibit 2 is a handwritten list of my clients and the priors she's able to recall at this time. Here's one for you, defense lawyer, court reporter, everybody. Say, I've given you those because I know there are things you're going to be interested in. It'll facilitate the deposition. Now, what is the lawyer going to do? They're going to say, I want to know about have you had any other crashes? They're going to reach for the binder in their list. They're going to say, I don't want you to look at it. They can't help themselves. And you're going to say, you really don't want them to look. We have provided you this. It's an attachment to the depo. You're saying you're refusing to let them look to give you the most accurate information. You want this to be a pure memory test. Yes. Okay. Don't fight anymore. Okay. If your client forgets one, who cares? At the end, you're going to say, now, ma'am, I wanted you to be able to look at it. You wanted to look at it. Before answering, they refused to let you. You listed these 4 things. I want you to look at your list. You handed them before the deposition. Is there more than 4? Yes, there's 5. Would you find the one you didn't talk about? I don't remember. Well, I do. You said these 4. Did you mean to leave that one out? No, I didn't. Were you hiding it? No. Would you write it out, hand it to them, and then hide it? No, I would not. I didn't think of it. Okay. Now let's go in the medical records. Look on page so-and-so. Is it right there? Yes. So not only did you list it, you gave them the actual record from it. I did. They wouldn't let you look at it. No. Were you hiding that? No. What does that record say? No. Is that true? Yes. Thank you. Did you get any treatment after that? No. Now, let them go to trial and try to use that one answer they got. Is it going to work? Not even close. Now, is this perfect? No, something's going to slip through that wasn't in the records and they forgot it. But good God, think of how fewer times you're going to have a problem with it. It's a little bit of a pain in the neck. Is it worth it? Well, it could take you several $100,000 off the value of your case. It could go from winning or losing. I'd say it's worth a little bit of effort.
Absolutely. I mean, that's gold. And going back to episode 1, we talked about mediation and making your case scary.
Yeah.
Not being aggressive, but making it scary. And when you pull those things together where you're facing those past priors head on, when you're putting together those little nuances on how this has affected your client's life and not just saying, hey, I can't golf, that's scary, right? How did you come up with this idea of being a bodyguard for your client and tying it into starting with the most basics of things such as a deposition?
Hard knocks. Not being a bodyguard and watching it.
Right.
I remember sitting in a deposition years ago, before my Morgan & Morgan days, and it was a med-mal case. My lady had RSD in her hand. I hadn't come up with any of this. And I was sitting there, And the lawyer said, well, let me ask, for example, with RSD, can you do your laundry? I've always been an acute listener. And I went, that's a bit of an odd question. And then they said, are you able to, for example, shake clothes out that are wet? And I thought, well, that's pretty specific. All my alarms were going off. They've surveilled her, and they got her shaking some damn jeans out. And I don't want her to say no. So I said, we got to take a break. And they said, well, you know, we've only been going an hour. I said, I got to take a break. I said, I don't care if we go in 10 minutes. I need a break. And I always had told my clients, if I say we're taking a break, I may just need to go to the bathroom. It may mean nothing. But I want you to assume, I want you to meet me on the break. Go to the bathroom and then meet me. And we were at my office, and my client came and met me. I said, do you have a washer and dryer somewhere they can see it? It's in my garage. Do you open the garage door sometimes? Yeah, when it's cool out. Do you take stuff out of your washing machine and shake it? She goes, I go hang them on a clothesline. I said, okay. I said, do you shake them? She goes, sometimes. I said, do you shake blue jeans? Because that was the question, set me off. Yes. Yeah, with this hand. I said, are you sure with just that hand? She goes, well, let me think about it. And she goes, well, actually, I will hold them with both hands, but I shake with it. I would never shake with this. I will shake here, but I kind of hold here. I probably have done that. I said, God almighty. We walked back in. They said, do you take clothes out? Yes. What do you do? I put them up on the clothesline. Do you take jeans and shake them? I will, but I hold with this hand and shake with the other. This lady was as honest as the day. She just wouldn't remember.
Sure.
She really wouldn't remember. We stopped, and I told her, I said, I don't know what else is coming, but if you get a weird-ass question that they wouldn't know, then you better assume the answer is yes. And she did beautifully. They got nothing out of it. That's an example of, I walked away going, I'm never going to depositions again without having a conversation about that. Every client back when I prepared them would hear that story.
Yeah.
And I would have them ready for it. So where does this come from? It comes from having sat through depositions and having my client say something stupid that hurt, that slipped through the cracks. And I thought, it's not because they were lying. Mm-hmm. I'm not saying I never had a lying client, but it usually was just a dumbass answer. And I thought, I'm not going to have you destroy your case because of a dumb answer that they set you up for. So I started coming up with stuff like this.
It's so important, right? And I think that those types of questions, where you shaking out laundry, kind of we all start sweating a little, right?
What's that?
One of the things that I've started doing during my deposition prep is always telling my clients, assume that every moment of your life has been surveilled. From the moment of the crash up until the minute they are asking you these questions. Assume they have been watching everything. And sometimes it helps and sometimes it doesn't. I mean, you can prep your client to your blue in the face and they get in, have you had prior back pain? No. Nope. And
it's defensive. I really think a big part of it is they think you're going to misuse this and I'm just not going to help you commit a fraud. Right. So they end up downplaying something because they know it's not what they're making it into. Yeah. And they're being offensive. I tell them that. You know, a lot of it's straight talk with your client. I'll tell them this. I'm brutal. When I would prep a client, I'd say, I want to be clear about this. You would like to get fair value, wouldn't you? And that's a lot of money because you're going through a lot of hurt. Yes. If I gave you $100,000, would you ever go outside, put it in a garbage bin, put lighter fluid on, light a match, and watch it burn? Of course not. I said, if you say, no, I haven't had so-and-so, or no, I can't do that, and they have you filmed doing it, or they have a record, because they're going to have a record of everything happened from your childbirth on. If you had an ingrown toenail, they're going to have it. They're going to have film of you doing everything when you didn't know you were being watched. If you say no, I want you to picture lighting a match to hundreds of thousands of dollars, because that's what you will be doing. And you will think you're smarter than they are. You're not. And you know what they're going to do? They're going to laugh at your face. They're going to go pop champagne, and you know what they're going to say? I got this dummy to fall into my trap. And they're going to laugh. And you're going to think you got up on them by not telling them. they're going to laugh so hard they're going to have to go to the hospital. Who do you want laugh last? Now, you tell them all, you're going to think, oh, I hurt my case. You know what you're going to do? They're going to go out to their car, call the insurance adjuster, and cry. I got nothing. She was smarter than me. She didn't fall for my tricks. Do you want to be the dummy they laugh at, or you don't be the smart one that makes them sad? You want them happy or sad? Be cute. Don't tell them you're going to win for the moment and lose in lighter fluid in matches. Or be smart. They're going to pay you a lot more. You hired me. Do you need me? Yes. Listen to me.
Yeah, great perspective. Great perspective. And sometimes it's even giving them that assurance. Listen, we can fix any weaknesses, but the one thing we can't fix is you lying.
Absolutely.
Or you giving an absolute answer that later turns out to be false.
I tell them, I don't give a damn if you had a crash in the past. Who hasn't?
Right.
I don't care if you're 40, your back's hurt in the past. If you tell me you've never had back pain, you are lying to me.
Worst thing they can do for the case.
Stop, don't do it. The more they see the clarity, the less likely they are to self-help thinking they're doing something smart and hurt. They're going to be dummies that still screw it up. They're going to be occasionally a liar that can't help themselves. But the vast majority, you're going to hold this down. So all of this stuff, whatever you can do to bodyguard and protect your client, fix the mistake on the spot, deal with as best you can proactively the priors. Teach them about the language of their case. Don't say, I can't, say, I don't, unless you absolutely just can't. And if you're not sure, say, I'm not sure, don't play sure. You think you're supposed to have every answer. You don't remember everything perfectly. Say, I don't remember so-and-so. If they show you a record that says you're having more pain before or less after than you recall, don't say they're liars, they're wrong. Just say, I don't recall what I said on any given visit. I just don't. But I can tell you that doesn't square with what I remember around that time. But are you saying they're making it up? Of course I'm not. Occasionally, if something's just dead wrong, then you say that's not right. They got it down wrong. Otherwise, say, I can't explain it, and I don't remember it enough, what I said on that visit. I can just tell you that I don't remember ever feeling that good in that time frame. I guess I could have. Teaching them about what's coming, they're not going to remember it all. Shorten your list down to the things. The absolutely essential, put on a piece of paper, here are the 5 things I want you to remember. Take it home, drill it before it, tell them on breaks, tell them again, and fix it live.
Mm-hmm. And there are some attorneys who I've seen try to do that same thing with the subsequent treatment. It's like that, I think, and let me know if you agree with this, more of the focus is really on them getting the details right about the priors versus when did you have an injection, or when did you see Dr. X or when did you see Dr. Y. Some of those issues don't seem to be problematic, right?
I don't remember. The ones that are problematic after are they went to the gynecologist and said, I have no pain.
Right.
You say, I wasn't seeing them. Yeah, but it says neck pain. I don't remember the visit, but I don't remember her asking about are you saying she made it up? I can't answer it. I can tell you, and that you could have them ready. I know around that time I got an injection. And if it's after, you go, I wouldn't have gotten an injection a week later if I was having no pain. Or I had an injection 2 weeks before. Maybe I wasn't feeling pain then. The injection worked for a little while. They don't have to memorize it all. Swoop back in if they get an answer you don't like. So you were having a lot of pain in this time, yes. And if there's a record that says you were pain-free, they're just wrong. Yes, it's wrong. Well, you can come back in and be ready. The key is this. You can't help your client get ready with medical records if you don't know them.
Yeah.
My biggest gripe with lawyers when I step in and try a case is the defense knows parts of those records better than they do, and that's inexcusable. You can't just look for the good stuff. You better look for the stuff they're looking for, because it's coming. And the one place you're almost always going to find it, their damn CME. They all want it. We call them CMEs in Florida. The spine doctor. They love doing a big report and billing for it and going through all the medical records. That's the first place I look when I come in a case. I don't want a MedCron. I want to see what he's highlighted. then the medcron. Then I want to know what's in the records because the medcrons are wrong half the time.
Mm-hmm. Yeah, absolutely. That's key.
So, all right, let's move on.
What else you got in your
Now we're
in your
going
treasure
from
chest?
bodyguarding. We're now up to building our war chest or getting ammo. And now we're talking about preparing. This is all the questions were about evidence. And it isn't just hearsay objections. It's how do I build the evidence that I'm going to use at trial? How am I going to limit their evidence? How am I going to build my evidence? So let's talk about the building my evidence. Let's talk about our witnesses that aren't our client. What about the treaters?
The doctors.
What about the doctors?
Yeah.
How do you deal with priors? Well, that can be dicey depending on where you're at. You know, in Florida, we've had laws that if you don't name them as a hired expert, you want to keep them a treater, then you can't be handing them a bunch of medical records. You're going to turn them into an expert. They may get them from other treaters. They may get them from your client. They don't need to come from you. There are smart ways to do it. I'm not getting into all that because it changes from jurisdiction to jurisdiction, and my only suggestion is you better play by the rules, play straight. But there is, within those limitations you need to always be aware of, you can have a treater that doesn't know anything about a prior. The answer about that prior, whether you're being a bodyguard and being smart when you prep them. You can meet with them, you can prep them, there's absolutely nothing wrong with it. In Florida, there's a jury instruction that says you should not reduce anyone's credibility because a lawyer meets with a witness. They're allowed to, there's nothing wrong with it. Even places that don't have that jury instruction, there's nothing wrong with meeting with a witness. So you meet with a doctor who's a treater, and there's a prior, you know they're making a big deal out of. You know it's not in his medical records because you prepared for his deposition by looking at his medical records and taking some time to think, if I was the defense lawyer, what would I try to accomplish? And now you're meeting with him and you don't want to give him a free pass. Again, play by the rules. But a lot of places there would be nothing wrong. Even if you can't show him, if you're allowed to show him the record, show him the damn record in prep, even if it's not in his records. So he's not surprised and ambushed. But let's say you're in a place that you can't just show him the record. If it's permissible, you can talk in hypotheticals. You can't say if there's a record that says hypothetically. If you're not allowed to show him the record, you're not allowed to tell him what the record said, probably. But you can just say, look, I want to ask you some hypothetical questions. If, hypothetically, my client was in a crash 2 years earlier and he even went to the hospital, would it change your opinions if they had no treatment after that at all? No follow-up with any specialist, no MRIs, no injections, no nothing. I would suspect their answer is going to be no.
Right.
And then you can say, well, if someone starts asking you about hypotheticals like that, would it matter to you? Would you want to know? You can certainly say, I'd like to know, I'm always happy to know things, sure. But whether it would matter to me depends on the circumstances. Can you tell me some more?
Right.
Because obviously, if they went out and had an MRI and it showed they had the same problem here, that would be important and could change your opinion. If they had no follow-up, it may, as you told me, have zero. So you'd need more, yes. So if you're asked, what would your answer be? Whether it mattered. It would depend on the circumstances. I need to know more. Do you know more? Tell me more. I'm happy to answer. You've just protected them because you know how many times I've walked into trial and the deposition says, yes, that would be important. Yes, I want to know. No, I didn't know. Would that matter to you? It depends, it might. And then they make a huge deal out of it. And it all is because it was a kind of a trick question in a vacuum.
Yeah.
You're not playing with facts. You're not twisting evidence. You're actually setting the record straight. That's part of being a bodyguard.
And if it's a discovery deposition, I think it's fair game on cross to show them that record because they opened the door. It's just discovery. The judge can keep it out. But now hey, Doc, let me show you what the defense didn't show you. Let me put this in front of you.
Absolutely.
Have them look at it, and then guess what? At trial, they can't cross them on, well, you never saw X, Y, and Z, because guess what they did?
They opened the door and you got to do it.
They opened the door and now they did see it.
So using the law of your venue, do the bodyguard work. Go prep your expert and don't leave them open to an ambush on something like that leads to a bad answer that's not even a truthful answer. It's a trick question. Head that stuff off within the limits of what you can do. And then other things. When you're looking into medical records, we know the game they love to play. They love to go through and say, here are all of the negatives in the exam. You did the straight leg test, it was negative. You did an EMG, it was negative. You did the Babinski or whatever the hell it is, and it was negative. They go through and get all the negatives. Well, guess what? You think this doctor who did those exams doesn't know they were negative, and he still is of the opinion that they had a herniated disc, needed surgery, and it was related to the crash? It's more trick questions. A little bit of prep. Doc, you did these are negative. Does that change your opinion? No. Why not? Well, because that doesn't mean anything, because you can do the nerve conduction study, and if it's not active at that moment, it's going to be negative. It means nothing unless it's permanent damage to it. We know it wasn't permanent because when I did the surgery, it helped with the nerve pain. This fixed the nerve pain, yeah. Does that mean they don't have back pain? No, they still have back pain. The surgery doesn't help the back pain. It just helps the leg pain or the arm pain. Okay. You get them all ready for that so that when they go through and do the negative, you come in at the end and say just a few questions. They ask you about these 4 exams were negative. Were they? Yes. Does that change your opinion? No. Why? And then let them explain it.
Yeah.
It's not an inconsistency. It's not, well, I know you would expect it to be positive. It wasn't, and that's really weird, but it doesn't change. No, they say, I'm not surprised at all. So you deal with the stuff that they like. Now, let's switch over to what I jumped the gun to. Now, what's the side where you actually are gathering ammunition for your case? And there are 2 things when you go to take their witnesses' depositions. I like to think of it this simply. There are 2 things you want, 2 purposes of taking one of their depositions. It's gathering intel so you're not surprised at trial, and gathering sound bites that you can use at trial. The sound bites go in 1 or 2 places almost. There are exceptions to everything, but generally 1 or 2 places. Opening statement, cross-examination of that witness. Sound bites meaning if I get a wonderful answer that's 3 pages long, it's worthless to read it back and impeach them. So you need to go extract the good part. If you got to ask it 12 times, ask it until you get a straight answer without all the good ones know how to bury it in a bunch of verbiage. Say, I'm going to ask it until the cows come home, and I'm going to get the judge on the phone if you don't give me a straight answer. And I'm warning you, I'm going to move to strike you as a witness because you're being evasive and you won't answer. And last chance, you just told me so-and-so. You now adding in all why it doesn't really matter. I want you to acknowledge that's your answer. If you don't, this is a 3rd strike. I'm getting the judge on the phone. If we don't, I'm suspending the deposition, and we'll come back later. And defense lawyer, if we can't get him back and can't get the judge and he doesn't come, I'm going to move to block him as a witness. This is ridiculous. You know our judge isn't going to put up with it. Pick a fight in front of everybody. Let them all get nervous. Now say, here's your chance. Yes, now you got your damn answer. It was worth all of that because you need the clean answer to use it at trial. Then you can stand up, the person says. And here are the kinds of things that I like to go look for to get those clean, straight answers. One of them is what I call shooting down defenses, and the other is what I call creating crossfire between experts. I'll give you a couple classic examples. The wouldn't hurt a flea defense. The defense is saying, look at these pictures, wouldn't hurt a flea. The doctor says you got a sprained strain. You don't want him to say, could be a sprained strain, because now that's not as powerful to use it in opening and in cross. I want a sound bite, I want it tight. If he says it may be a sprained strain, no more than a sprained strain, you can almost always get him to say it is a sprained strain. How do you do it? You say, sir, you say it may be a sprained strain. My client went to the doctor. My client got this treatment. You say that treatment was reasonable and necessary for this first 6 weeks, right? Yes. You're not suggesting, are you suggesting my client went to the chiropractor as a big fake scam? Of course not. Okay. So you think legitimately accept they went there to get treatment for what you call a sprained strain? Yes. Therefore, your conclusion, the most likely explanation is they had a sprained strain. You say not a herniation, but a sprained strain. Yes. So it's not may, it's reasonable medical probability. You're saying it's a sprained strain? Yes. Well, all that wrestling is helpful. Who cares if it may be or it is, because you say it's bullshit, it wasn't a sprained strain. Here's why. When you get up an opening statement, you can boldly say, with confidence, because you locked it down. You didn't let them get away with may. They said that's their conclusion. Opening statement. The defense is going to show you this picture. Say it wouldn't hurt a flea. Look at that. There's hardly a scratch. It's just a little tiny fender bender. Here's the problem. They hired this guy. They hire him all the time. They pay him a lot of money. They're asking you to rely on him, trust him, and believe him, and base your decision on him. And he says that picture resulted in my client having an injury. Period. Not maybe did. That's his conclusion. He's going to tell you that hurt him. So keep that in mind when you hear a suggestion it wouldn't hurt him. Now, he says it wouldn't hurt him bad, but it hurt him. We're going to talk about why wouldn't hurt him bad. It was just a boo-boo in just a minute. And then you roll into, he says it's just a boo-boo, wasn't a big deal. Well, here's the problem. Didn't have problems before, started with a crash, never went away. It's the same pain that he said was caused by the crash. Never went away. What's his alternative explanation? Well, for 6 weeks, it was hurt from the injury in the crash. Some point they went to bed 6 weeks out, woke up with the exact pain in the exact place. Now it's got nothing to do with the crash. It's all just a big coincidence. Now the natural aging process explains it, except it's in an exact place and it didn't come back a year later. It never went away. And the aging process was going on for the 10 years before and not causing any pain. His answer is, yes, you were hurt and yes, it caused the exact pain we're here suing over. Except at some point it just switched like a lightning bolt out of the sky, hit him in the neck in the same place, and now it's the aging process that's been going on 10 years, decided to hurt him right there in the same place in the same way. So when he says it's just a boo-boo, it doesn't add up, it doesn't make sense. But what's important is he acknowledges they got hurt in the crash, and they're acting like the pictures prove he wouldn't get hurt. You couldn't do all that if when you were in the depot, you didn't get him to say it, and you didn't convert it from may to it can. Now, if they've already done a written report and says he diagnosed it as a sprain strain, you don't need to go through all that. But the new game is may, because they know what I do to them on this, and word spread, and they're trying to go from the diagnosis of the injury to a may. Don't let them get away with it. That's preparing. Here's another one, exaggerated malingering. How you ask it matters. You want them to ask it in a way they think you're wanting them to say, yes, they're malingering. Say, are you suggesting my client's malingering or making it up? No, because they want to sound reasonable. Then convert it to, so you're saying you found no evidence of that. No, I didn't. And that wasn't limited to just your exam and your interview of history. It also includes everything you reviewed. Yes. Now they can't say, well, I didn't see him doing it at the moment I saw him. Now everything they've looked at. So when the defense lawyer comes, you stand up an opening statement. Tell them, this is what I'm saying. In cross, you reiterate it. Sound bites for opening and cross. You get to stand up and opening and say, you may hear suggestions my client's exaggerating her injuries. Courtroom's not a place for hinting. We talked about that in jury selection. It's a place for saying what you mean and backing it up, but you may get a hint. Objection, argumentative. Sorry, Judge, I'll do better. Now, the jury knows. Then you say, if you hear any suggestion that my client's exaggerating, they hired the same guy, rely on him, trust him, make your decision on him. He looked for it. He looks for it all the time. He sees it from sometimes. He knows what it looks like. And it's not just an exam. He looked at every single record they're showing you. Every record from the past, every record since. Every one of the records they're showing him, they showed him. He looked at them, he studied them, he's charged a bunch of money for it, and he's on their team, and he says there's no exaggerating at all, period.
Good stuff.
It's just, do you think they're going to adjust? No, they're going to walk right into it. You can't do that with gusto if you haven't done the gathering, the beginning stuff. One other example of that, crossfire, bulge versus herniation. One of their witnesses say this is a bulge, and the other, and therefore it can't be from trauma. The other one says it's a herniation. You can kill them an opening. They say they can't even keep their story straight. You can say it a little less argumentative, but make the point. Or what's more often, they both call it a bulge, not a herniation. Now they're at crossfire with the treaters, but they also have internal crossfire. They've hired two people, paid them both a bunch of money. They use them all the time, and they can't keep their story straight. The one guy says a bulge isn't from trauma. The other guy says it's less likely, but it absolutely can be. It can be. It's not a bulge, it's a herniation. But for goodness sake, they want you to believe both of them, and they can't even tell you the same thing. objection argumentative. I'll do better. You've destroyed them in opening. You can't do any of that if you have not treated the workup phase as trial prep. That's when people ask me about evidence, that's what evidence means to me.
Absolutely.
Now, I'm going to touch on just a couple things before we finish this up. Motions in limine. You tell them what the difference makes in motion in limine practice. I know you use them because I see your results.
Yeah. Motions in limine are so pivotal to the trials. When you go in and the judges want you to be prepared and they want you to meet these deadlines and they want you to file these motions, by going into trial and having these decisions made already, not only you're on the judge's good side because you're not coming up with all kinds of last minute stuff, but you're protecting your client, you're being the bodyguard, and you get to get up in opening and you know what will be addressed and what won't be addressed. And that gives you an advantage because you're setting up your case knowing what evidence is going to come in and is not going to come in. The worst thing is getting there into opening, trying to address it, the judge being like no, and then having to make a contemporaneous objection after the jury's already heard it. And you know what, sometimes those comments, sometimes that evidence that comes in, it's not a mistrial, it's not something that is going to even necessitate a curative, but it's something you can't get back. All of that can be avoided by following the motion.
You got to decide, am I going to deal with it in opening myself so I don't give them a free shot?
Correct.
I don't
or
know
voir dire. Or voir dire, right?
Or voir dire.
Yeah.
We're going to address the prior conviction. If it's coming in, I got to address it.
Yeah.
If it's not coming in opening, I probably don't want to address it in voir dire because I want to win the case before it comes in and the judge is leaving and no one's talking about opening and we'll decide after they're on the stand.
Yeah.
I'll just wait and see.
It's a mess.
But if the judge says you should have brought it up, if they want to bring it up in opening, they can. If there's a good chance it was never coming in, you can't not deal with it.
Yeah, it's tough, right? And going back to even the mediations on the first one, you start making those motion in limine lists in mediation. You listen to what the defense is saying. You think, oh, need a motion in limine on that. Oh, need a motion in limine on that. During your depositions, you're making those lists. And you're filing them then. You're not filing them last minute. You're filing them well in advance. You're getting them set for hearing. And listen, easier said than done, of course, right? We're all busy. But it is such a key piece of bodyguarding your case and being prepared in advance. And, you got to keep that stuff out. Some of it you can't come back from.
You cannot. And the last thing we will touch on is social media. I'm actually going to save that because we're going to talk about it in the voir dire section, which is our next session. And we've used up our time. I plan to deal with it. But for everybody that's saying, by God, you covered evidence and you didn't talk about social media, you didn't talk about surveillance, we're going to get to it.
Yeah.
It's a huge piece of this. It is a big piece of evidence. I promise you, tune into our next one. I'm going to move it into that section because it straddles both. Talking about evidence sounds a little less exciting to me than cross and openings and closings, but none of that matters if you haven't done this part as well as you can do it. It'll never be done perfectly, but we have the power to minimize the damage, maximizing the strengths, and why wouldn't we use that power? And all it takes is a little planning and a lot of commitment, and it makes you the difference between a pretty good lawyer and an exceptional lawyer.
100%. Thanks, Keith.
Yep.
You can't have a good trial unless you have a good foundation of the case. Things like taking the depositions, making sure your client is prepared, getting those sound bites, such great things that we got today. So the next couple episodes are going to be what Keith calls winning before beginning. And that starts with voir dire. Then we're going to go into opening in the session after that. But it really talks about the foundations of voir dire, getting it biased, and making sure you're ahead before the case even starts. It's a lot easier to start off ahead than it is to catch up.